Dani, do you remember when we first met?
Hey, I was thinking about this when I got the email from you. If I had to guess, it was trial by combat, but it might have even been before that.
You are wrong. Do you want to guess again?
Okay, then I would have guessed it would have been a tournament in undergrad, so maybe like beach party or something like that.
Delaware never got invited to the beach party, sadly.
Sorry,
And
okay,
you know
tell me.
what's so great about this question is we don't have to rely on your memory or my memory because there is actually video footage of you and me meeting for the first time.
This was nationals my freshman.
Yeah, and there's you and there's me.
My God, wait.
And
Did you remember this without looking at this?
so actually one of your teammates or someone from Miami sent this to me. Um and
Oh, that's awful.
I'm not going to put the audio on. I'm going to spare both of us the horror of listening to ourselves
Yeah,
from
please do.
a decade ago.
If I
So
had to guess, it's that man, Ben, who sent it to you. If I had to take a guess, and he will be hearing from me because I can just know if the audio was on, I would be sitting here cringing so bad.
yeah, I don't think it was Ben.
Oh, all right, fair enough.
Yeah, I don't think it was Ben. I'm not going to get Ben in trouble. So yeah, so this was round two nationals, in 2015. So like you said, your freshman year, my
Yeah,
senior year.
yeah,
Um, and the weird thing about it is, so nationals were in Cincinnati that year.
yes.
I remember walking into that courtroom, and it felt like an away game, uh, in like a crazy football stadium because it was packed with Miami people, like totally
For
packed.
sure.
Like the
No,
jury
we were
box, all Miami people.
very lucky. I had friends so my immediate family and like high school and everything is outside of Columbus. So, Cincinnati's an easy 2-hour drive. So my parents were there. I had good friends from high school there. And then even with Miami only being 45 minutes, a bunch of the younger students were able to come. So yeah, I can imagine that we did make it feel that way.
So do you have any memory of that trial? Understanding you don't remember me, and that's okay.
I do. I remember we were having a lot of demo issues, which we kind of knew going into the trial. So that was the election fraud case. And Ben, who was just on screen, was my witness, and he was the like pollster journalist type guy.
Yeah.
And we had thought of 77 different ways to like get all these poll results in. And we thought for sure it was coming in. And then I'm pretty sure you guys kept out our like entire demo. We didn't get any of the poll results. And so Ben and I are like making up this whole direct on the spot with our whole demo covered. So that's what I vaguely remember of the round.
So that was one of the best mock trial rounds I've ever watched. And I just like remember it being super intense. One of your teammates used a line in his closing, John Spear, that I use with my teams, like to this day sometimes. Yeah, I remember he said, I don't remember what the context was, but he said something like, you can't assume that because you didn't hear that. You didn't hear that because it didn't happen.
The plaintiff is asking you to assume that there was an agreement between Casey French and Mayor Heisman. The plaintiff is asking you to assume that that envelope had something incriminating in it. That they're asking you to assume that in that meeting they were talking about spreading lies, but you can't assume that because you didn't hear that. And you didn't hear that because it didn't happen.
And
I have reused that line a million times over. It's a very Miamiism probably. And I'm sure someone adopted it from someone who adopted it from someone, but very popular line for sure.
yeah, and just one of the best. You guys were one of the best teams I ever remember seeing, and the round was a split decision, and one of the better rounds I think I've ever seen, and definitely one of the best rounds I was a part of as a competitor. So
Well, thank you. That's so kind of you to say. I think because I was so nervous, honestly, like I said, the piece of the round that I remember is my whole direct getting thrown out. But it's nice that you remember it as this like beautiful, competitive, wonderful round.
So you guys had, I went back and looked at this today to prepare for this episode. You guys had four really dominant years, your 4 years at Miami. You at nationals all 4 years. I think you were third your first year. I think you were ninth your sophomore year, second your junior year, and then obviously you win the division your last year. Or do I have that messed up?
Flip sophomore and junior, and you've got it down pat.
Right.
Yeah.
So third, second, ninth, first.
Yep.
And then, of course, you guys go on to win the national championship 4-3 over Yale, right, in 2018 in a really, really close and intense final round. When you sort of started your senior year, after all those great finishes at nationals, did you sort of feel like it was win the national championship, or who cares?
Honestly, no. I think especially because we had finished ninth my junior year. For us, in recent Miami history, we were like, oh man, we were horrible. We're never going to be good again. We had gone off of the third and second finishes. And so ninth was a real kick in the teeth, honestly. So we came into that year, and the previous year we had a very heavily senior stacked team. So we had a lot of people who had never competed at nationals, or maybe had competed once. And so we, by no means were we expecting to win. Was it like a high pressure year? It's always high pressure to do well, but by no means did we think we were going to win the whole thing.
How surprised were you when they announced that you guys were advancing to the final?
So less surprised than I would have been. My team, normally Miami is very strict about going blind for the whole tournament, but we had done 3 rounds. We had just finished up against U Chicago, and our coaches are asking us right before round 4, oh, do you guys want to go back to the hotel? Do you want to keep practicing? And they sit us down and they're like, okay, you guys are 8-1. You're battling. As long as you get 2 ballots, you're in the final. Are you sure you don't want to go practice? And so we were like, okay, fine, we'll go practice. So less surprised, just because I did know going into that final round against Lafayette that we were in a pretty good spot. I think we could even have only picked up 1, and a tie break might have come out in our favor, which, not to say we thought it was guaranteed by any means, we did not, but we definitely knew like it was going to be a good round, and we felt comfortable about where we were at.
Yeah, if you got 1 ballot, you probably would have advanced. You guys were 11-1. The next best team was UVA at 9-3. So you really just needed 2, and you won the 4th round by huge margins, plus 25, plus 20, plus 8. So just a really decisive round 4 and a high at nationals, which really never happens.
Yeah, we were pretty excited about it. The round started off a little contentious before everything started. I don't remember the exact reasoning. I mean, Miami, we're kind of a feisty team, so people wanted to argue with us all the time. So it wasn't that shocking. So I remember going into it, we already were fired up and ready to go, even aside from knowing that it was kind of choose your own destiny is Neal Schuett's favorite kind of turn of phrase for that, either choose your own destiny or something along those lines, where it's like, it's all up to you. It's in your hands. You guys get to control your fate type of vibes. So we were very excited.
What was it like working with Neal?
I loved it. I've been very, very fortunate to work with tons and tons of amazing coaches over the years, including when I was in law school. But I've seen, as we just saw, horrific footage of how I was as a freshman. And to think that Neal saw A, potential in that, and B, knew how to actually make me better was incredible. I think my number one thing that I would say about him is that some coaches are good with some styles. You might have somebody who's a really good witness coach, or a really good coach for aggressive attorneys, or a really good coach for whatever typecast mock trial you might think of. For me, Neal is the most universally applicable coaching style. He can make anyone good. He can make any witness better character, whether that's, the expert being more scientific, or the defendant putting on some more tears, or whatever it might be. Neal has an ability to take anyone's skill set and amplify it 20 times. And I think that was the best part about working with him for all 4 years.
I've had this discussion on the show with a number of competitors, and listening to you talk about Neal and sort of coaching generally, I think you're someone who might be on my side in this debate. So let me pose this question to you. First off, how heavily coached was Miami, at least while you were there?
Totally depended on the team and on the year. One of my favorite parts about Neal is that he was going to coach you enough where you were getting pointers, or he would give you specific language here and there, but he also knew how important it was for things to be made your own. Definitely some of the other coaches on other teams were more hands-on. They were wanting to see your Google Docs script and make edits to it. And hopefully you were going to stick to that. But I would say Neal's approach was, okay, we have to hit A, B, and C, but you get to pick how we weave through those things. And I'm not going to control too many aspects of the theory or the actual content of the examinations or the statements.
When you went to Wake Forest, and we're going to talk a little bit about Wake in a few minutes, but when you went to Wake Forest for law school and you competed on their trial team, how heavily coached was Wake Forest?
Mark Boynton was my coach at the time. So as you know, law school mock trial is so much less centralized than undergrad. And so the way Wake broke it down, we had our NTT or our TILA team and then our AAJ team. We would take members of both to blend if we got an invite to the Tournament of Champions, which we did at least the 2 years I was able to compete in it. And so my coach, I was only on the TILA team, was Mark Boynton for the most part. And then I also had assistants from Sunny Haynes and Ashley DeMuzio. Mark is an enthusiastic coach. He heavily coaches you, kind of the same thing as Neal. Like, he's really going to push you. He's going to give you ideas, but he's never going to make you, read off of a script. A lot of the times you're going to love his ideas. And so you're going to want to use like exactly what he said. I certainly recorded his little spiels at practices many times. But for the most part, he's just like our biggest cheerleader or dictator, or whichever term you want to use.
So there are lots of undergraduate programs out there that are totally student run, sometimes because they don't have necessarily the resources or the Rolodex to find a coach that could help them with any degree of regularity. But I'd say some of the really good student run programs are largely student run by choice. So as someone who was heavily coached at the undergraduate level, but also obviously pretty heavily coached as a law school competitor, do you think, here's my hypothesis, the student run teams like a Tufts, for example, that are doing really well year in and year out, but they're student run, they don't really have a ton of support from a local lawyer or just someone with mock trial experience who's practicing law, maybe even not practicing law. Do you think that those teams would be better if they had a Neal Schuett working with them?
I mean, yeah, I think any team would be better with a Neal Schuett, but we can even use the hypothetical of, not somebody who I would say is one of the best coaches I've ever had. I think that what coaching brought for me was Neal or Mark, whether I was in undergrad or law school, they were able to play the bad guy. And so when it came to personnel decisions, or when it came to disagreements on theory or call or whatever it might be, Neal took the fall essentially, or Mark was the one that said, okay, guys, I'm going to make the call here. And that meant that I became such good friends with all of my teammates. And that's not to say that people in student run programs don't become good friends. They clearly do. But I definitely would say, at least from anecdotal conversations, there is always that degree of like, well, my teammate who's on the exec board gets to pick who they want on these certain teams. And I think for me personally, and for maybe some of the personalities that were at Miami, we were very lucky to have coaches who would be the bad guy and kind of make those really difficult decisions in an activity that we all care about so much. And so of course we want the best, but we also think we know best. And so you kind of need somebody to play, ultimate decision maker, I think.
I agree with everything you said. The other thing that I would add is that clip that we just watched from our 2015 Nationals trial. If I watched myself, give my cross and my direct during that trial, I would be horrified, setting aside sort of the performance stuff, just from a content standpoint, because there's probably so many decisions that I was making from a content standpoint in that round that are just like senseless and even to just like a normal lawyer who has no mock trial experience are just so obviously stupid. And when I compare that to the way that I competed as a law school competitor, it's night and day in so many respects, but especially from a content standpoint. I learned how to actually craft a cross-examination or a closing argument in a way that was actually effective rather than just sort of scoring mock points. And it probably wasn't as true for you. And I would guess if we watched that Miami-Delaware round, the biggest sort of striking difference between our two teams is, my guess is your team was probably a little bit more cohesive in terms of the content than we were.
No.
For sure. But that coaching made all the difference for me as a law school competitor, working with Justin as a 3L, but also just like the other coaches that I had, it helped a lot. And
I
so
think that, oh no, sorry, I'm interrupting you. Go ahead. I have a crazy funny anecdote that for me is like the epitome of why having someone who is at least like taken the bar is great or gone to law school. My younger brother is currently a competitor at Penn State, and they are student run. And he'll occasionally call me up with a question here or there, want to ask me about what I think of an objection argument or something. And he called me one day, and without revealing too much, because this was this season, his team was trying to come up with a creative way to get some hearsay evidence in. And he's like, well, if we don't call the defendant, can we use unavailable witness rules to get it in? And I was like, no, you cannot. Absolutely, you cannot. And he's like, why not? And I was like, well, one of the very first rules is that the witness can't be available. If a defendant's not available, you're not having a trial. Like, they have to be there. So he was like, oh, yeah. And so I think that him and his fellow teammates, or at least I won't speak to his fellow teammates, but he was so excited that they thought they had come up with this like creative idea of how to get the evidence in. And it was like, well, let's step back from mock trial for a minute and just think realistically, could that happen? And the answer was no. And that's something coaching will bring you.
Yeah. I remember as a freshman at Delaware, my first year competing, thinking like reading Rule 403 and making the argument to my teammates that because something was so helpful to our case, it had to be super probative and that therefore admissible.
I believe you.
Like, that makes sense to me.
I'm sold.
And there was no adult in the room to tell us that doesn't make any sense.
I love that you phrased it as an adult, because that's how I would be.
Yeah, and I think you're right about the sort of bad guy thing. The way my first coach at Drexel's, Jared Rosenblatt, maybe Jared. He's now Hofstra's director.
Yeah.
And the way that he would describe it is, you need to have a river, like through the opening and the directs and the crosses and the closing. It all needs to sort of hit the same points and flow cohesively. And one of the big fears I have for teams that don't have a coach is like, who is making sure everything sort of fits together? Everyone is sort of doing their own thing, particularly in undergrad when you've got 6 witnesses instead of 4 in most law school tournaments. Like, who is checking that everything makes sense? And when we call this witness, these exhibits will be in, and so we can do that. Who is making sure that river is in place if you don't have someone who's like in charge? And obviously, like you said, the undergraduate teams are figuring it out and figuring it out at a very high level. I mean, it's hard to argue with, for example, Tufts results or Harvard's results. They're doing really well. But my guess is they would be even better on the margins if they had a coach. That's been my hypothesis on the show. People have yelled at me and been very upset about that as a take, but
glad we're aligned. I will back you next time they come for you with pitchforks. I'll be right there ready to defend you.
Perfect. Love it. I don't want to get us too far off track. I want to talk a little bit more about your time at Miami. So I counted today, you won 19 individual awards as a competitor at Miami, all attorney awards. I think the most impressive of which is obviously your 2 All-Americans as a senior, being the second ranked attorney in the prelims for your division, and then obviously being in the final, you get an All-American. What accomplishment as an undergraduate competitor are you most proud of?
Obviously the national championship. I mean, we have to start there. That's like the kind of easy one. I would say my second biggest accomplishment was the first award I ever won. It was my freshman year at regionals. I was actually a swing or a middle. I don't know what's your favorite term of art there.
Middle.
And so I was a middle, and I won an award as a middle. And of course, now in hindsight, I know that awards mean nothing. But as a freshman, I was like, this is my first regional. This is my first award. And my teammates were so happy for me because they had seen how mad I started out, just a few months prior. They had seen most of my directs be completely thrown out. They had watched as I got like pulled off of statements, which is why I was middling. Like they had seen me struggle to get there. And so we get to regionals and like somehow the pieces were just falling in place the way they were supposed to. And I was very, very proud of that. So I would say that was kind of the first time I was like, oh, maybe I do just kind of get this thing. Maybe this is sort of my shtick, I'm a one-trick pony and this is my trick sort of. And I think from there, it really built my confidence going into all of the years after that. Yeah, I would say that's probably it. Of course, like I said, besides from the national championship.
So it's 2018. Miami is cruising along. Eventually you win nationals.
Yes.
And at some point during the spring semester, you are invited to the inaugural trial by combat in Philadelphia in June of 2018. Now, as you may or may not know, do you keep up with mock trial confessions, Dani?
Honestly, like I'm still on there on Facebook, so I see the occasional post here and there, but not a ton.
Yeah. So one thing that I do to prepare for these episodes is I will type in the competitor's name and then mock trial confessions to see what people write. And I'm not going to show any of them because I don't know that they're YouTube appropriate. You may get thrown off.
Honestly, what's hilarious is that I'm actually lucky because when I started, there was like the old page and now there's the new page. So I think the old page is fully deleted and you might not have been able to see all of those ones.
Not deleted. No, it's there. They're all there.
Oh, well, I mean, wow. When I tell you my sophomore year, that entire page was like, we hate Miami. Miami sucks. Everyone hates Miami. Dani Kunkel sucks. John Spears sucks. Adam Court's like calling out every single one of me and my teammates. We were so hated and we loved it. Oh, we would sit at practice like, did you see this new one today? We loved it. But anywho, wow, this is embarrassing that you saw all of those.
There was one that I was gonna put up, but it was actually more of like a compliment to you. So it wasn't like I like having competitors read their mean confessions about themselves, but it was sort of like mean to Miami, but nice to you. It was like, hey, Miami, what are you gonna do now that Dani's gone? I guess you'll just rig orcs like always. And that one made me laugh.
Okay, so did you ever look on Twitter? Somebody live tweeted our final round, and to this day, my friends and I quote, there was one that said, and this will give you your mean tweet. One said, Kunkel has just shown how loud and petty Miami can be.
Sounds like a compliment.
I was like, I mean, listen, I'll be loud and petty holding up my trophy, okay?
So the reason I bring that up is obviously now, as you may or may not know, there is a lot of controversy about the selection process. I mean, I literally just brace myself from like April and May of every year, just getting crushed online for the selection process. But then it was kind of a new thing. It was like this new tournament. I remember talking to Justin about like, are people even going to want to come to this? And you accepted your invitation. So when you first heard that we were going to be doing this competition, this one-on-one event in Philadelphia, and you were going to be selected for it, how did you feel? How did you feel going into the event? What were your sort of expectations? What were your thoughts?
That's a great question. So Neal came to me, and he and Justin obviously have a relationship. So I want to say that Neal had maybe, and this could be a total lie, but my memory says that Neal maybe had some whispers from Justin that he had been thinking about putting together this kind of competition. And so Neal had told me about it, before we sent in my application or whatever we did. And at the time I was like, heck yeah, a trip to Philly, competing one more time, one last hurrah. Of course, at the time that we accepted, I don't think nationals had taken place. So I didn't know that it was going to be, on the heels of a victory. So I was just like, all right, let's go like one more time. I was obviously very, very flattered. I knew that, there were so many great competitors. I mean, somebody on all of the, what's it called? The perjuries or all the websites where they compile all the data and stuff. I remember as they kept picking more and more people, they would put like all Americans, all this many awards, that many awards, this many awards. And I was like, oh my God. I was like, I'm going to go to this and get 16th place. And everybody's going to be like, Miami sucks once again. So I was very nervous because I felt like there was a certain degree of kind of expectation and pressure going into it. And I would say those probably sum up where my scrambled brain was at.
So I have a couple memories of combat as relates to you. So number one, my memory is that you were like the favorite or one of the favorites for sure going into the tournament,
Oh, nice.
especially after
Love
winning
that.
nationals. We didn't do a semifinal that year. It was the only year we didn't do a break to 4. We did a break to 2. And my memory is that you were in what was the de facto semifinal against Nick. Okay.
Yes. I was, which sucked, but I mean, he went on to win. So being able to say you lost to the winner is like, okay.
Yeah. And I remember popping into that round and watching 30 to 45 minutes, which is like most of the trial. And I don't think I hope Nick won't be mad at me for saying this, but I remember walking out thinking, oh, Dani definitely is going to win this.
Oh, that's nice of you. It's very nice of you because I had the exact opposite thought. I walked out and was like, yeah, I just lost that round.
Well, so interestingly, I didn't see this part of the trial, but and maybe it wasn't from this round. Maybe it was from your other attorney round. But I heard an anecdote, and I wonder if you can confirm this, that one of the presiding judges in one of your trials made some sort of ruling that was bad, and you asked to put something on the record to preserve it for appeal, so that way she might be reversed at some point by the appellate court. Do you recall?
Oh gosh, sorry, this is Nugget. She apparently has some thoughts on this. Girl,
Yep.
come on.
Yeah, we'll hear from her. Do you remember that?
What I recall about it was that the judge, she said overruled or sustained, whichever. And I said, on what grounds? And she goes, on my grounds. And I was like, got it. The time in my head, it wasn't as rude as it really was. In the time in my head, I was like, no, I genuinely am curious. I want to know how you decided that. And I think after the fact, it was sort of, she had gone with maybe the law school rule. And I, of course, was like, no, you got to go with the undergrad one or whatever. But I mean,
what was the rule?
I would have loved to have like better judgment at the time and not have said that. But no, that was not in the round against Nick. That was in the round against, he was from UVA, Dennis.
Dennis, yeah.
Yes, it was that round.
Drexel's own Dennis.
Yes.
What was the law school versus college rule issue?
I don't recall at this point now, which is probably like good that I've let it go. I'm sure if you would ask me even 2 years ago, I probably could have told you, but I just remember Neal and I go in the hallway and he's like, okay, you were right, but like, did you have to do it that way? And
well, what's interesting about that?
Have you met me?
Yeah, I remember hearing that at the time and thinking, whoa, that's crazy. But now being a trial lawyer, like that happens all the time in court. And lawyers will say, I need to put this on the record for appeal, judge. Like I have to. So
I saw a trial where the judge dismissed the witness, dismissed the jury just because defense counsel wanted to like get up on a soapbox and scream at the judge. He was like, you're tying our hands. We can't do our jobs. And then the judge was like, anything else? All right, court's dismissed. I was like, just so justified.
I mean, no shame in 3rd or 4th place at the inaugural trial by combat. That was a pretty good couple of months for you.
Yeah, I think it actually ended up in like 6th because I remember I was right outside of the trophy placing, and it was like top 5 got trophies, and then Rachel and Nick went to the final. But I was best witness, which was crazy. So that was like I rode home and was like, all right, anyone who ever said I wasn't allowed to be a witness, you're wrong.
Yeah, I mean, one national championship is more than most people win ever. So
fair enough.
We have no sympathy for you. So then to fast forward a little bit, you end up at Wake Forest. How did you end up at Wake?
I knew that I post law school wanted to be somewhere in the Midwest. I'm now in Pittsburgh and I was aiming my sights towards here. I grew up outside of Columbus, and so I kind of wanted a similar size city, similar vibe. I still have extended family out here too, so it was nice to be close to family and everything. So when I was applying, my criteria were sort of, where can I get in? Where can I get some scholarship money? And will I have decent job placement sort of in the general Midwest, ideally like Pittsburgh, Philly, Columbus areas? Wake, I don't know what made me think that Wake had great Pittsburgh placement. I mean, we quite truly place about 1 person per year in Pittsburgh. But I think it's more just that you have to go out of your way to apply where you want to work. We don't have, on-campus interviews from Pittsburgh employers, but I just like direct applied to all the firms I wanted to end up at. So yeah, Wake, it was well enough ranked, but not so great that I wasn't going to get a good scholarship offer. That was definitely a huge factor for me. The location was great. I did know that they had really great trial advocacy programs. So that was kind of the cherry on top, was I knew I'd be able to kind of continue this disgusting obsession that I have. And so, yeah, all the perfect storm, and I ended up in North Carolina.
You compete. How many years at Wake did you compete?
At Wake, they only allow students to compete 2L and 3L year. So those are the 2 years that I competed. My first year they have intra-school competitions. So I did kind of all of those, and I would help out the trial teams with practices and scrimmages and stuff, but I didn't officially join the team until my 2L year.
What competitions did you go to?
So Wake doesn't go to a ton of competitions. I hear now, I feel like every month I'm seeing that UCLA Law has won another tournament. And I'm like, I didn't even know this many tournaments existed. I truly only went to Tournament of Champions both years, and then my regional for TILA both years. We won our regional my 2L year, but COVID canceled nationals. And then my 3L year, we won it and went to nationals. So I competed only in a total of 5 tournaments in my whole time at law school, at least that were inter-school competitions.
So I think one question that some people have, at least I have, is why did you not go to Top Gun either year?
So my 2L year, they actually only took 3Ls because COVID had kind of like destroyed their last semester and everything. So they put out a statement that was like, we are only taking 3Ls. We want them to have the last opportunity to do a competition. That's not to say that I would have been accepted anyways. Like I said, I had only competed at 2 tournaments in law school, so I didn't have the same law school trial resume that I did for undergrad. I did apply, but like I said, they were like, sorry, we're only taking 3Ls, which was a bummer because one of my fellow Miami teammates actually was competing that year. So I would have loved to be able to go against him, Imo Kaiokolo. And he ended up getting, I think, in the top 4. So he absolutely crushed it. But then my 3L year, not to get too depressing, but at the time that they were choosing it, I had a family health situation going on. And so I ultimately decided not to do it. My coach and I talked about it, and it just wasn't the right time for me. And you know what? I was really lucky. Wake had so many amazing other options for competitors, and Jack Kasemsi ended up representing Wake Forest, and one of my dear good friends, Jared Koenig, was her second chair. So Wake had a wealth of talent, and it was really great that they were able to represent the school. So
one question that I ask prominent college and law school competitors is, which did you like better?
I liked the style of TILA better, I think, just because there's something so exciting about going into a round. You meet your witness 15 minutes before, and you have no idea what they are going to say. You go into your woodshed and you give them all the advice in the world, and you're like, please, like the one sentence I need you to say is this. They don't say it. You're doing a cross, and like half the time the witnesses want to fight you just because they want to fight you. The other half of the time, they just agree with everything. So you kind of get to like really get the ball rolling and just keep pushing and pushing. And so I would say the adaptability and unpredictability of the TILA style, I loved. Obviously, I still liked the undergrad style. And when I competed at Tournament of Champions, your witnesses are still on your team and stuff. So I still liked it that way. But I definitely think law school, for my enjoyment, was preferred.
Well, this episode's going great. You agreed with me about the coaching thing. You agreed with me about law school being better than college.
Yeah.
I should have you on every episode.
Please, next question. I'll be a co-host. No, but I think the other like small thing that I really loved about law school is being able to make motions. There's so many things that I'll judge undergrad rounds now, and I'm like, oh man, if we could have just taken this up pre-trial, I feel like that would have streamlined the round, or you could have used an exhibit in your opening or something like that, or we could have skipped past a lot of the stuff that kind of eats up time. Like, let's just pre-admit a bunch of these exhibits, even if it's not stipulated to, and stuff like that. I felt like that made it a little bit more realistic to like go to the meet and confers. We have a real conversation about what we're going to agree to, and then we're going to go, argue right off the bat to hash out all the other details. So I loved that aspect of it as well.
We're about to watch your cross-examination from the TILA National Championship in 2021, and you've used that term TILA a couple of times now. For those who don't know what TILA is, can you tell the viewers?
That's the Texas Young Lawyers Association. At Wake, we actually don't even call it the TILA team. I've picked that up because we called it the National Trial Team, but I learned that that's not, a universal term. I think I said before we got on this that law school's kind of so much more segmented in the trial world than undergrad. And so you kind of never know if you're all talking about the same thing. But so the Texas Young Lawyers Association, they come out with the cases every year, go figure. Pretty frequently they're like oil and gas related and stuff like that. And so then the regionals are all over, and nationals is always in Texas unless it's virtual, like my year was, because it was 2021. So
yeah. So to supplement your answer, and feel free to correct me. In
Please.
law school, there are sort of two big spring tournaments that every law school does that have a regional and national, and they're hosted by two separate organizations. The first is hosted by TILA, the Texas Young Lawyers Association. The name of the tournament is the National Trial Competition. Very creative, hence the National Trial Team at Wake. The second sort of big national competition is frequently called AAJ. It's hosted by AAJ, the American Association for Justice. And the name of that tournament is STAC, the Student Trial Advocacy Competition. Again, very creative. And there's sort of two big events that just about every law school competes in. The big difference between the two events is at the TILA event, the witnesses are live, meaning the witnesses you woodshed or prep 15 minutes beforehand. And AAJ is more like a traditional AMTA round in the sense that the witnesses are your teammates. And so the round that we're about to watch is the 2021 TILA National Championship, which was, as you said a second ago, the year we were on Zoom for regionals and nationals. So have you watched this round back?
I've seen bits and pieces, for my own piece. I normally avoid watching too much of my old footage, and also I guess for my own ego. So I've seen bits and pieces, and I've definitely seen pieces of this cross as well.
Yeah, I'm gonna spoil it for the viewers. This is a round against UCLA, and you guys lost a really close trial to UCLA. This is UCLA's first TILA National Championship. So my first question before we get into this is, do you hate Justin? And if yes, what do you want to say to him?
I most certainly do not hate Justin. In fact, fun behind the scenes about that round, he sent me a personal email as we were waiting for the results. There's a pretty long gap period between when the round ends and when you get the results. And he sent me a very kind email that was just like, congratulations on your career. I'm glad that we hit you in the final, that kind of thing. So no, I absolutely adore Justin to this day. I'd like to think that, we don't stay super caught up, but I would like to think if we ran into each other, it would be, a very cordial conversation about how freaking successful UCLA is. I think that Wake was the last team to even make it to the TILA final that wasn't UCLA. The last 2 years have been UCLA versus UCLA. So he's clearly doing something right out there. I'd probably actually, what I'll say to Justin is that I'm jealous, and good for you. And that's awesome.
Your first incorrect answer of the episode. Really disappointing. That's okay.
Oh, I'm so sorry.
Okay, so last question before we're sort of synopsis of the case for those who don't know. This was the year, so TILA, just like AMTA, alternates between civil and criminal. This was the civil year. For those who don't know, what was this case about?
Part of it was a bus crash. Basically, the plaintiff said that she got her face cut up by the glass on the windows from the bus, and she sued the bus manufacturing company Aerocoach. And in the round we're going to watch, I was on defense, so I was representing Aerocoach, and the plaintiff was Courtney White. We'll see when the round starts. And so she sued and said, had you manufactured this bus within safety regulations, my face wouldn't have been cut up like this. And ultimately it was a car crash. This guy crossed over the median, hit this bus and knocked it onto its side, and then the glass shattered and cut her up.
So we had two teams at nationals this year. One that made the final, the playoffs at Tyler, which is the final 8, and we lost our quarterfinal 3-2. And had we won, we would have had you guys in the semifinal the next morning. So that would have been
Congrats
fun.
to your teams. That's awesome. And bummer to have missed Wake. Mark Boynton is no longer coaching there, but they still have Ashley DeMuzio, I know, and I'm not sure if Sunny is still involved, but they still have excellent coaching down there. So always a proud alum to see them succeeding.
We scrimmage Wake pretty frequently. We scrimmaged, you mentioned your former teammate, Jared. We scrimmaged his Tyler team a couple of years ago. We scrimmaged Ashley's TOC team this year. So they're a frequent friend of the program, and we like scrimmaging them. But without any further ado.
Oh, gosh.
Counsel, Ms. Kunkel?
Yes, Your Honor. May I proceed with cross-examination?
You can.
Thank you.
It's hard to tell
Mr.
I'm
Murray,
mad.
you talked a moment ago.
What did you say?
It's like you can already tell I'm mad. Like the way that you can hear, at least that I can hear, that I'm purposely going, okay, make your voice sound really nice. Make your voice sound really nice. Don't sound like a bitch right away. Oh, just a dead giveaway.
So let's talk about that for a second. Obviously, like, if you read the confession, perjury, whatever, that was like the thing people would say, like, she's so mean. Like, were you cognizant of that criticism, and were you thinking about it all the time?
I would say in undergrad particularly, I really was a bitch. I watch rounds now from back then, and I'm like, oh my God, what was I so mad about all the time? I didn't know how to pick my battles very well. And so any argument was like the biggest argument. I would like to think that once I got to law school, and particularly in this round, I brought the heat only when you actually needed to bring the heat. And I don't think, I'm never insulted by anybody saying that I'm being bitchy or mean or whatever, because I think that that was a shtick, that was a style. Everybody chooses the style that they go for. I would like to think that if most people met me in real life, they wouldn't think the same thing, but I'll let them be the determiners. But yeah, I mean, everybody chooses their style, like especially down at Wake. Part of why it was so great that I had a more aggressive style is that we're in the South. And so most of my teammates kind of were a good foil where they were the nice one, you know, good cop, bad cop sort of relationship. And so, yeah, I was very cognizant of it. Being in the South for our regional, I really worked on it. Being in Texas or virtual Texas for the final, I was aware that I needed to kind of keep some of my more passionate urges in check, I would say.
Ago about a memorandum from within Aero Coach. Do you remember that?
I do.
You know that it was written by an employee of Aero Coach, don't you?
That's right. I think it identifies the executive vice president, Marcos Rosales.
Right. And you know that there were some redlined words on that document, weren't there?
That's correct.
You actually talked about some of those redlined words a moment ago.
I did.
I don't think we said this yet. This is the cross-examination of the plaintiff's bus expert, whose opinion is the windows are defective because they're too big and break very easily.
Yes. Yeah. And fun fact about this pocket, I had never done this pocket in my life. There was a pretrial motion about this exhibit where the judge is kind of ribbing me, and he goes, you know, Ms. Kunkel, I can't wait to see how you're going to handle this on cross-examination. And I was like, no, I don't have any pocket for this. So I was like, well, I guess the judge said I've got to handle it, so I'm going to handle it. And I asked him some crappy questions, and I don't think I get any good admissions out of this, but we'll see. We can be pleasantly surprised together.
Yeah. And for context, the case was about a bus and whether the windows were safe or not. And basically there was this memorandum that was drafted by the company where I forget exactly what the wording was, but basically like, hey, these windows are dangerous. Then there was another version that was like redlined it was like a draft version that had red lines in it that had worse stuff for the company. Like, these windows are super dangerous. What are we doing? Like, kind of stuff. And there were pretrial motions about whether the redlined non-final version was admissible. And like you said a second ago, you made a motion eliminate to exclude the worse red line one for your client, and that motion was denied. And here we are cross-examining on it.
And you know those words did not end up in the final version of that memorandum, did they?
Yeah, the Aero coach chose to keep those opinions internal and not external.
Well, sir, you never spoke to Marcos Rosales, who wrote that memo, did you?
Experts typically don't get to speak to the defendant's employees.
Mr. Murray, I'm not asking what's typical. I'm asking if you spoke to Mr. Rosales, and you didn't, did you?
I did not.
So you did not ask him why he wrote those words, did you?
I did not.
You did not ask him how he came to those opinions, did you?
That's correct.
And you didn't know if any single other person at Aero Coach also held those views.
I do not know that, no.
Because you didn't interview anyone else from Aero Coach either, did you?
No, I did not.
You never interviewed Courtney White, true?
I read her deposition.
Sir, I'm not asking if you read her deposition. I'm asking if you interviewed her, and you didn't.
I did not interview her.
In fact, you never interviewed anyone who investigated this accident, did you?
What do you think so far?
I love my trial voice. Everyone talks shit about it, and I stand by it, first of all. Second of all, I remember I was already my hackles were raised as we're getting into these questions. And he's like, well, it's not standard to interview. And I'm like, I know that. And you know that I know that. And I'm like, so let's answer the question. So this was, like you said, or am I thinking about that? This was a prime example of just be calm, just be pleasant. And you can tell that I'm searching for my words in a lot of those questions. And I'm kind of biding myself time in the middle of a question to like decide where I'm going to go, because it, like I said, it was completely unplanned and I didn't want this pocket in my cross. So
I remember two things jump out at me watching the first minute of this cross. The first thing is your witness control is so good, and it seems sort of easy, but I think that's mostly because you're making it look easy. You do a really good job of identifying when to control the witness and how to control the witness. And so it's really, really good. The next thing that sort of jumps out at me is sort of the obvious thing, which is that you're sitting down in like what appears to be like a tiny, like little conference room. So we're at this point in time, we're like a year into the pandemic from a mock trial perspective. Like Trial by Combat and Top Gun online the first time it was the year before. So why did you guys decide that you were going to sit for exams and speeches?
So fun fact, we were actually in Mark Boynton's law firm in this round. He was able to get us all separate offices in the firm. So that's the background that you're seeing. He works for, well, at the time, I don't know if he still does. I haven't talked to him in a minute, but he was at Kilpatrick Townsend. We chose to sit because we had tried a couple scrimmages where we were standing, and we just felt like we kept running into technology issues, you know, whether the audio wasn't coming through clearly or somebody was objecting or trying to share a screen or something and it wasn't working. And so then we had to awkwardly like walk up to the screen and fix it. And so we decided that it was going to be more effective to just get our facial expressions and, you know, more minimal hand gestures being closer to the camera so that that audio was really coming through. I would say I was a pretty strong proponent of on our team of not standing up, of staying seated, because I think that what I would say I learned more and more throughout law school is that your volume is one of the most important facets of your presentation that you can control. And if we are too far away such that you kind of have to speak up the whole time, I felt like we were going to lose that ability to have those more quiet moments or, you know, the tonal changes as noticeably. So that's why we ultimately went for sitting. I know a lot of teams did not. Most teams stood. At UCLA we were facing, they were standing. And yeah, I think there's pros and cons to doing it both ways, but that's kind of where we came out.
Other person at Aero Coach also held those views.
I do not know that, no.
Because you didn't interview anyone else from Aero Coach either, did you?
No, I did not.
You never interviewed Courtney White, true?
I read her deposition.
Sir, I'm not asking if you read her deposition. I'm asking if you interviewed her, and you didn't.
I did not interview her.
In fact, you never interviewed anyone who investigated this accident, did you?
That's right. I read some reports people made who investigated. I did not personally interview anyone.
Well, sir, we're going to talk more about those reports in a moment, but because you reviewed those reports, you know that this crash occurred on Interstate 20, right?
I do, yes.
You know, the
This
speed
was one of
limit on
those
I-20
pockets
is
where
80 miles per hour.
I was trying to set up some stuff for my direct later in trial. So I'm kind of asking some overly benign questions. We had a demo basically that kind of laid out the interstate and how the crash happened. And I could get that info from my witness, but I knew it was a little bit easier to just get it on the record immediately with this one. So I'm like, you were on this interstate and it was 80 miles per hour. So it's kind of, I always hated this line of questioning because I knew the judges were probably sitting there going, okay, why does this matter? But it was, you have to your point before talking about the river of how is this all going to flow together. I felt like in law school in particular, my team and I focused a lot on like, what balls do I need to put on the tee for my teammate to hit later, or for me to pick up later, or for me to swing for the fences in closing. And so This is one of those prime examples of that.
Don't you?
That sounds right.
You know that this accident occurred when Gary Winters crossed over the median and struck the bus.
That's true. That's true.
Now, you said a moment ago that when you performed this analysis, you looked at the bus.
Try to look at the pictures of the bus.
Well, that's right. So you only looked at photos, true?
That's correct.
You never went and examined the bus in person, did you?
That's also true.
Now, you reviewed the NTSB report on this accident, didn't you?
That's correct.
That's the National Transportation Safety Board.
That's right.
And you know the NTSB is an independent agency responsible for promoting highway safety, right?
Correct.
And they wrote a
This was
section in this
another
report
piece
that
of
they
evidence
titled,
that we had never used before. In pretrial, we agreed to pre-admit it. And so I had never run because normally we didn't need to use it, and other teams would object or not enter it or whatever. And so I had never run a pocket before with it being in evidence. And the other side actually was like, no, we want to pre-admit this. And part of the reason teams normally did not pre-admit it, and when we were on the plaintiff, we did not, is there was some kind of damning evidence about whether the driver of the car was high or something like that. And so there was a lot of strong stuff for the defense. And so I was excited for the opportunity in this case to be able to use that exhibit. And I think if I recall correctly, after this, we're going to get into what is my favorite part of this cross, which is the picture of the bus on the cranes. So I'll tee that up.
Yeah. And so there was, to sort of give your answer some context, there was a report done by the National Transportation Safety Board about this bus crash. And I think other than the driver being high, which is obviously a big fact for the defense, the driver of the car that hit the bus, not the bus driver.
Yeah.
I remember that the way that document was used by the defense mostly was to say, hey, there's nothing in the NTSB's report that says this bus or its windows are defective. And so why are you saying it's defective if the NTSB, the independent sort of expert in this litigation, they're not saying that. And so that being a really damning piece of evidence for the plaintiff.
If I do this cross correctly, which I don't remember now, I will have asked a question like that. So
Find out.
Fingers crossed for past Dani.
Probable cause, didn't they?
That's also true.
And in that section, they included several causes of this accident.
That's true.
They mentioned the median system on the highway, right?
That's right.
They mentioned Gary Winters crossing over the median.
That's true.
They never once mentioned a single concern with the windows on
There it
Aero
is.
Coach's bus, did they?
That's right. They were focused on the cause of the accident, not the cause of Miss White's injuries.
Well, sir, they did examine some of the safety features on the bus, didn't they?
That's correct.
They looked at the seat belts, right?
That's true.
And they never once said that they had any concerns with the windows on the defendant's bus, did they?
That is not in the report. That's true.
Now, you know that this bus rolled onto its side during this accident, right?
That's accurate.
You did not see when the window shattered, did you?
I was not there.
You did not see what state the bus was in immediately after the accident?
I saw pictures of it, and I heard Miss White's testimony earlier, but I was not physically there. That's correct.
Let's take a look at one of those photos. I'm sharing with the witness what's already been entered as Exhibit 2. Mr. Murray, can you see Exhibit 2 on your screen?
I can't.
So I don't know if you remember this, but my memory is that so for Tyler Nationals, it's sort of like AMTA Nationals in the sense that you only get like 4 weeks to prep. It's really short prep. And my memory is that there were some, I forget exactly what it was, but some complaints about the one photo in the case about the bus that didn't show X, Y, or Z. And so it was a problem. And so they added this photo pretty late in the game, like
They
2 weeks
did.
before Nationals,
Yes.
to the case. And it's like a pretty, I mean, it's one of 2 pictures of the bus. So it's a pretty important exhibit. And so I remember
Well-
scrambling to try to figure out how we were going to incorporate this.
The best part of this is that this bus is so clearly a different bus than the one that's in the other picture in the case. And I guess part of that makes sense because no, actually, now that I'm remembering this, it was like Courtney took a picture that morning of the bus before the accident. And then this was allegedly the bus after the accident, and they're completely different. And so I think there might have even been like something in the case that was like, okay, you can't actually argue that they're different buses. They're
Yeah.
the same thing.
So-
But when we got this picture, we were excited.
Yeah, there were 3 pictures now that I remember it. There was one that the plaintiff took, like, oh, I'm excited to get on this bus, which is a totally weird thing to do. Then there was a picture of the bus overturned.
Mhm.
And then they added this one.
Mm-hmm.
And I actually think all 3 pictures are different buses. But you weren't allowed to say that.
Yes.
I'm sure the scoring judges were like blatantly not the same bus. What are we doing?
We purposely would not introduce the non-crashed bust a lot of the time because we were like, we knew, yeah, as you knew, that the rules said, okay, we're going to act like these are all the same. But we were cognizant of the fact that the judges are going to look at this and be like, these are completely different buses. And so if I'm remembering correctly, we purposely were a little hesitant to use the shiny new pictures of the bus.
Permission to publish Exhibit 2 to the jury, Your Honor, that's been pre-admitted?
Permission is granted.
Yes, Your Honor. So, Officer Jokel, Mr. Murray, it is dark outside in this photo.
Officer Jokel's the witness that you're about to do the diagram with that you're teeing up here. So you had Jokel on your mind.
Well, we had also done 4 rounds in a row of plaintiff. And so when we got pulled for defense in this final, we were like, oh man, we haven't done this in like 3 days. And so, yeah, definitely Jokel was on the mind 1,000%.
Photograph, isn't it?
Yes, it is dark in the photograph.
You know, this accident occurred in the middle of the afternoon,
I do know it occurred in the afternoon. That's right.
around 3 p.m.
That sounds right.
And this was in the middle of July, wasn't it?
The July 4th.
So you know that between the time of the accident and the time this photo was taken, at least a few hours passed.
That seems right since it's dark outside. I don't know what time it gets dark in Lone Star, but I assume at least 3 hours passed.
Okay, so you assume at least 3 hours passed between the accident and when this photo was taken.
Yes, when you have an accident like this, I mean, the investigation, getting the bus up is going to take a while.
You don't know what happened to this bus during that 3-hour period, do you?
Personally, no, I do not. I've read reports of people who came on the scene after and heard Miss White's testimony, but personally, no.
And sir, you can see in this photograph, the bus is actually being held up by 2 cranes, isn't it?
That looks accurate, yeah.
You don't know if those cranes caused any further damage to the bus, do you?
The cranes cause further damage? No, I do not know if the cranes cause further damage to the bus.
The old crane conspiracy theory.
So I remember the day of practice when we took a real look at this photo and we had this aha moment of like, wait a minute. The cranes totally could have not shattered the windows. We weren't trying to say that they hadn't already been shattered, but like most certainly lifting up this already damaged bus totally could have caused further damage. And it didn't really matter whether it had or it hadn't, or what extent. What matters is that he couldn't tell me that it hadn't. And so that was kind of always the point of this whole cross, was that, you know, this picture, we were like kids in a candy store as we dissected all the different ways we could try to fight with the witnesses about it.
Thank you, sir. And you mentioned that your concern with this bus was the windows. You said one of the concerns was the size.
Yes, well, coupled with the non-glazing, but yes.
Sir, you know there aren't any federal regulations regarding window size, are there?
That's accurate.
There's no Lone Star standards regarding window size.
That's also accurate.
You cannot even tell me what the ideal dimensions for these windows would be.
You know, it's a specific situation, that when it comes, regulations are generalities. And so, yes, I can tell you that if you're going to make large windows, if you're going to make the biggest windows in the industry, spend $87 in glaze.
Mr. Murray, I'm looking for exact numbers here. You cannot tell me what the ideal dimensions for these windows would be.
I can tell you unglazed windows should be smaller than Airbus's windows. I cannot give you an exact diameter.
And you never even measured the windows on this bus, did you?
I looked at them, and it's pretty obvious. I've looked at tons of buses, and they're the largest windows. And Aero, the defendant, actually acknowledged this. So,
where I truly did just have to be like, all right, don't fight with this man, because in my head, he's like, well, I looked at them. And I'm like, okay, we know you looked at them, but that's not what I asked you. I asked you if you measured them. And we both know you didn't do that. And so those were the prime examples of witnesses can get under my skin so quickly. And honestly, if a lot of them had realized sooner how easily they could get under my skin, they certainly could have pushed me around more.
Well, what's interesting is I think like this particular witness is being sort of evasive in a way that's like ridiculous. Like you'll say, you know, you didn't measure the windows, and he'll be like, no, I didn't go out and measure the windows, as if like your question is like outrageous. Like, I can't believe you're asking me whether in a case about the size of the windows, I measured the windows. So I sort of think, in your defense a little bit, he kind of deserves a little bit of more aggression than you're giving him here. And I think you're holding yourself back a little bit.
Had I rolled my way, I certainly would have lit him up more, but I kind of knew we were getting into some series of questions where I was going to want to argue with him more. You might have just heard he did that throwaway about like the $87 per window. Yeah. My team and I, we had read the exhibit, and honestly, at this point, I don't remember the full details of it, but we stood firm that there was an argument that it was not 87 per window. Like that metric was based on XYZ, and they should have considered ABC, right? And so I was already getting geared up, ready to fight him on that piece, which we will see, unfortunately, that's where this cross definitely devolved. Ultimately, the judge was like, why don't you move on, counsel? And I was like, all right, fine. So yeah, I think I was sort of reserving my anger to let it out later. And of course, it's nice to hear you say like he was being kind of annoying about some of the answers, because of course I think that as he's like giving me sass on every single question. But it's easy when you're in the heat of it to take it personally or think that they're being difficult when really, you know, they're just answering the questions.
I did not take measure to them. I didn't need to conduct my analysis.
Sir, I'm not asking whether they were the largest in the industry. I'm asking if you measured those windows, and you did not measure them, did you?
That's accurate.
Now you're saying that the windows should have been glazed, in your opinion?
That's true.
There is no federal standard requiring glazed windows, is there?
That's also true.
There's no Lone Star standard requiring glazed windows.
That's correct.
Now, you told us a moment ago that some companies do glaze their windows, right?
That's true.
So you're saying that now, in 2021, some bus manufacturers glaze their windows?
I'm saying some bus manufacturers, both in 2014 and now, glaze their windows.
Sir, I'm looking for a name here. What bus company do you know of that glazed their windows back in 2014?
I don't have a name.
I'm looking for a number. How many bus companies can you tell us with certainty today that you know glazed their windows back in 2014?
A few. I cannot tell you an exact number.
So you're saying you know a few glazed their windows back in 2014?
That's right.
You remember when you were deposed before coming to court, don't you?
All right, so before we get into this impeachment, because it's a big part of the cross, and I want to make sure we spend time on it. So let's take a step back.
God.
So for those watching who are college competitors or high school competitors who aren't familiar with the way the law school world works generally, and particularly the Tyler rules, basically the Tyler rules are if the witness doesn't explicitly say they did something or that something is true, they must admit that that thing is not true, right? So, and I'm not explaining that very articulately, but the point is the witness's statement here doesn't say, I can't name any bus companies that glaze their windows. It just doesn't say the names of any of those companies. And so under the Tyler rules, if you ask the question to the witness, you can't name any companies that glaze their windows, the witness must answer no under the Tyler rules. It's one of the sort of the, I think, heavily debated sort of rule distinctions between law school and undergrad. It's one of the places where I think the undergrads are right. I don't think we should be able to just like invent for any reason, but the rule that we use at Battle of the Experts, which is Drexel's Law School Invitational, is, well, two rules. One is we allow the teams to ask discovery questions, meaning you can ask any witness any question a couple weeks before the tournament, and we will answer it. We'll fill the gap. I try to do as detailed of a case as I can. That way we don't need to do that, but that way, all case writers miss things. Yeah. But after that, to the extent that you ask a question to a witness on cross and it's not contained in his or her, deposition or expert report, et cetera, the witness can say whatever they want. So in this situation, the witness would be able to say Greyhound or whatever.
Yeah.
And so you can debate which one is better. My guess is the undergrads would be very upset if they had to use the Tyler rule.
I liked the Tyler rule for the purposes of the Tyler competition. I think the fact that you meet your witness 15 minutes before and they don't know this case as intimately, for that reason, I actually really appreciate the Tyler rule, because to some extent, these witnesses are not going to remember what's in the reports or the deposition. They already are going to be making things up. And so I like that the attorneys, since the witnesses aren't scored, I like that it's a very attorney favorable rule. And I like that they had it. And of course, I say that as I'm about to botch an impeachment, I'm pretty sure. But I do think in undergrad, it would not work because your witnesses know the case so well and they also are scored. And so I think that would put an unfair kind of hindrance on witness performances and witness creativity. Like I said, I like the rule for Tyler because I felt like I wanted more witness control and having that ability was great, but I definitely see the pros and cons.
Yeah, I mean, part of the issue is, if you remember, there was and this is where the $87 figure came from. There was a really long bus, very technical, long document. And so to expect some random law student, or in this case, random attorney, to know the whole case really well, including really long technical exhibits, they're just not going to. And so you sort of have to keep the witnesses' statements short. That's why super technical witnesses like this in a live witness competition aren't always ideal. You want to keep the cases simple. But I'm actually going to defend you on this impeachment when we watch it. I watched it back for purposes of the episode, and I thought you got a raw deal. So we'll watch it and then we'll talk about it.
I'm looking for a number. How many bus companies can you tell us with certainty today that glazed their windows back in 2014?
A few. I cannot tell you an exact number.
So you're saying a few glazed their windows back in 2014?
That's right.
You remember when you were deposed before coming to court, don't you?
I do.
You remember you promised to tell the truth?
I did.
Remember you promised to include all information that might be important for your conclusions?
I answered the questions that were asked. If I said that, then that's accurate.
Sir, you were specifically asked about the fact that some bus companies do.
The witness said, I answered the question that was asked. That's important, and we're going to come back to that in a second.
Glaze their windows, weren't you?
I believe so, yes.
And you never mentioned that some manufacturers glazed their windows in 2014.
Objection, Your Honor. You're saying improper impeachment? May we be heard at sidebar?
You may.
Your Honor, defense counsel is attempting to impeach Mr. Murray with his prior statement. To do so, she needs to have him have the statement in front of him, have him lay the foundation that this copy he has is accurate. None of these steps have been followed, and thus at this point, this is an improper impeachment.
So Chandler's objection, this is the judge sort of rules in a way that has nothing to do with Chandler's objections. Chandler's objection here is, this is Chandler Matz, Georgia Tech alum, UCLA competitor, obviously. His objection here is show the witness the statement, let him verify that the transcript of his deposition it actually is the transcript, and let him look at it, basically. The judge's ruling has nothing to do with that, so let's watch it.
Ms. Kunkel?
Your Honor, it's an impeachment by omission. When he was deposed, he promised to include all important information, all relevant information, and he never once mentioned that these manufacturers glazed their windows in 2014.
I'd love to not respond at all to the objection.
Doesn't that depend on whether he omitted it? Doesn't that depend on whether he was asked the question?
So you're in fairness to the judge, your response is sort of not, because Chandler's objection is just so sort of like basic. I think you were almost expecting it to be something more technical, and that's why you responded that way.
Procedurally correct. I should have shown the witness the deposition, but I didn't want to because I already knew this cross was going to be long as shit, and I was trying to save time. I was like, maybe he'll just like agree with the question without it. Again, part of why I like Tyler. A lot of times you could just like get the witness to roll. I should have known that Chandler would be on it and like not tried it, but I was like, let's see if I can just get him to go with it. Totally did not respond to his concern whatsoever. And so then the judge, of course, as you said, was like, oh, well, if the witness was asked about it, which, as we discussed, the Tyler rule is really, really specific. And quite literally, there's a quote that is like, witnesses cannot say that they were not asked about XYZ. And he even was asked like a question somewhat on point. I'm remembering listening to this now. I hate the language choice that I'm using about like some manufacturers, this, that, and the other. And I remember us crafting it during scrimmages and practices where it was like, we had to draw this really careful line to make sure it complied with the deposition, but I wanted to just let this point go, but I really couldn't, because it was like the linchpin of our case was who's to say that Aero Coach had to do this because nobody else that they can prove was doing it. And so it was like, had I fought the battle a little stronger and actually responded to the objection, it probably would have gone over better. But yeah, I like clearly tuned out, didn't want to introduce the deposition, and then the judge was like, yeah, I think he can just go ahead.
Yeah, I want to respond to what you're saying. So let's listen to the judge, give the rest of his explanation, and then let's talk about it.
I think this, well, doesn't that depend on whether he omitted it? Doesn't that depend on whether he was asked the question? I think this omission line of questioning has gone far enough.
Your Honor, am I permitted to just get an answer on the record for this question, or would you like me to move on?
I'd like for you to move on, please.
Yes, Your Honor.
Okay, so this is a really important sort of lesson for competitors, for coaches, for judges, for hosts, for case writers, for everybody. This is super important. So there's so many things going on here. And again, like I said, I'm going to defend you here for a second. So you say to this witness, where do you say that and to be fair, I don't remember what the case said, but I'm going to assume that our memory is correct, that the witness's deposition does not say that I know a few companies glaze their windows. Let's assume that for sake of discussion. And the witness says, well, I answered the questions that were asked, and in parentheses, I wasn't asked that question. And then the judge sustains their objection on the grounds that, well, doesn't it depend on whether he was asked that question? And like you said a second ago, the rules are such that you cannot say as a witness, I was not asked that question at deposition when you're impeached by omission. And the reason for that is because if a witness could say that, it would defeat the whole purpose of the impeachment by omission rule and the negative space rule that you can't say things unless they're in your deposition. Otherwise, there's no point of having the rule if the witness can just say, I wasn't asked that.
Yeah.
So what's so crazy about all this is that, and again, I'm going to defend you here. The Tyler competition is run in part by the ACTL, the American College of Trial Lawyers. The witness is an ACTL member and the judge is the president of the ACTL. So if they don't know the rules, how on earth can we expect the people scoring the round to understand and grasp the concept of what an impeachment by omission means? There's no way. It's not possible.
Yeah.
So when I go into protest or when I'm on a protest committee and a protest committee says to me or a coach argues to me, well, they impeached by omission, so isn't that good enough? Or this one makes me the most mad. Well, your student didn't impeach, so therefore they don't deserve to win the protest. Well, the whole point is maybe the person in the round doesn't think the judge is going to appreciate their impeachment by omission. It's not a thing that happens in a real trial. It's a mock trial thing. And so you're in the unfortunate situation where you've got a judge and a witness who both clearly don't understand the rule, and there's certainly nothing you can do about it in that respect. If I can criticize one thing, and then this would have been really, really gutsy to do this, and you've so many things going through your mind, so it's hard to have the wherewithal to do it. I would have read the rule onto the record right there and said, the rule says they can't say that, so that's why I'm doing this.
It's so funny that we talked earlier in this about trial by combat and me being an absolute a-hole to the judge and saying under what rule, because it stuck with me definitely that even though I was right, it didn't really matter because I came off so poorly. And so in this instance, while I was right, I felt right, I am proud that for once I exercised judgment to be like, you know what, this is not like the end all be all of my case. I'm just going to have to let this go. And hopefully the fact that I directly asked the judge, can I ask this question? He says no. My mind was like, hopefully that's enough that the judges will say, all right, she's listening to the judge and like, that's what she's got to do. But I totally agree. Like in hindsight, I would love to be like, well, judge, I don't think you're correct there, sir.
Yeah. I mean, it's hard. It's really hard. I mean, it's easy for me to say, watching this several years later, that's what I would have done. Who knows what I would have done? I love when judges or like coaches are like, that's what I would have done. Like, no, you wouldn't have. You wouldn't have done that in the national championship with everybody watching live. But it's just like protest committees, case writers, rule writers, coaches, judges, like understand that impeachment by omission is a very mock trial thing that judges don't appreciate. They don't know what it means. It doesn't matter what you said in the judge orientation. They're not listening. And so, I think we can argue about whether that was an effective impeachment by omission, but like, you're definitely correct about the procedurally and technically what you're doing.
I think that, like you said, now that I've been practicing for a few years, and that's not to say I'm frequently in the courtroom, I work in big law, but I've been in courtrooms and I've seen how real lawyers act. I think had I had the perspective I have now, I might have been like, screw you, judge, I'm reading this rule and you got to let me ask this question. But I think we are taught more in trial team and in undergrad, and especially because these are people giving up their weekends to help you out. Like there's a certain degree of extra respect that we were instilled to give. And so, no, like I said, no regrets that I handled it that way. But now I definitely, like you said, right? Easy for me to say now I would handle it differently, but who knows how I would have played out.
There's only one time as a competitor that I can remember doing anything like remotely challenging the judge. And not even like a pat myself on the back. It was just like, I think I was just so nervous about it and my like soul left my body that I just didn't know what else to do. So it was actually at Tyler Regionals, the championship against Temple, and we're plaintiff, the civil case. And I'm offering like the defendant's CEO's statement, and Temple objects hearsay, which I was shocked by. It's obviously a statement by an opposing party, and the judge sustained it. And it was like, we needed it. It was the defendant's statement. So I just like, I'm not patting myself on the back. I wasn't like calm. I was very nervous in the moment. I don't know what even came over me, but I just like went for it. And I very politely said to the judge, Your Honor, I want to make sure I understand, is the court ruling that statements by an opposing party are not admissible in this trial? And maybe a risky move, but I said it very nicely. With a smile, and it was in Philly, and I did my like Philly shtick, and maybe she liked it, I guess. And she was like, okay, yeah, you're right. I forgot, overruled, and let it in. And so I think there's a way probably to kindly tell the judge you made a mistake.
Yeah, my go-to was often, can I try another response? I always, if I got overruled or sustained or whatever it was against me, and I thought I had something else in my back pocket, I was always like, can I try again? And I would say that probably worked about half the time, and half the time they were sick of hearing me yammer on for 27 minutes in the objection argument. So they were like, just move on. But that was always my go-to was, can I try again? Or, well, Your Honor, can I actually be heard? And they're like, all right, fine.
I think like one of the and sort of, again, mock trial is judged by real lawyers. Like this is a real trial thing, but it also might inform the way you compete because there are real trial lawyers judging you at big events, especially. To me, in the trials that I've done, one thing that is very obviously on the judge's mind is whether the judge is going to be, whether they're going to be reversed on appeal by something they do. They're very afraid that, hey, if I do this, this could be a major problem for me down the line. And so I've seen really good lawyers politely say to the, and again, this is why, like the thing we talked about with combat, I actually, in hindsight, don't think it was bad that you did that. At the time, I was like, that's crazy. But now, as being a real lawyer, I'm like, yeah, that's totally what you do in that situation. Dani was definitely right. But like real lawyers say to the judge, Your Honor, like, I think you're sort of treading, like, you got to tread delicately here. This could be a potential problem. You know, if you do this, then this, and if you, and what about this? And so I think there is a way to politely, nicely, respectfully say to the judge, you are making a big mistake here, judge.
That was the problem with my trial by combat approach, is that it was not polite. It was not respectful. It was like dripping with sass and sarcasm. And I was like, on what grounds? And she was like, mine. Like,
yeah.
You got me.
I would score a competitor up who did that politely.
Yeah,
I wasn't in the room, so I can't speak to how you said it, but
mine was an instant down. Now, granted, it's so funny having been such an aggressive competitor. I kind of am split whenever I judge rounds now. Sometimes I really appreciate somebody's, zest and passion and all the adjectives that I might use. And then other times I'm like, what are you so mad about? And I think back to what I was like, and surely that would probably be the number one thing I would have asked myself, particularly as a college competitor. What are you so mad about? I was ready to fight the second we started pretrial. I'm like yelling in pretrial. There's just no reason. But I was so caught up in how I felt ready to throw hands the second we started the case, and I was letting everybody know immediately.
Now, Mr. Murray, you didn't run any tests to see what amount of force it would take to break the windows on Aero Coach's bus, did you?
Run any tests? No, I did not.
You ran no tests to see how the windows would break in the event of an accident.
By the way, truly the worst expert of all time. Like, he's hired to evaluate how good these windows are. He doesn't see them in person. He doesn't measure them. He doesn't run any tests on them. Like, what did this guy even do?
Yeah, I remember when we were trying to think of stuff for direct, we were like, how are we getting any of this in? And so on cross, it was always a field day. I was like, all right, let's go. And yeah, he was set up for failure.
Yeah, he was basically just like a professional internal memo reader for us. We're just like, and sir, how bad is this memo? And he was just like, really bad, pretty bad.
Other than comparing it to the previous crash, that is correct.
Well, sir, you don't know what kind of glazing they used on that other bus, do you?
I know it's glazing. There are several types of glazing, so I don't specifically call which type, but I do know they glaze
Love
the
that
windows.
answer.
Sir, you don't know how much force was exerted during that other crash, do you?
I know that the bus rolled over, and these are similar sized buses, so the force is going to be similar when a bus of that size rolls.
There's this expert who's like looking around a lot.
Yes, first. And second, this answer that he just gave has given me nightmares for years. Had I had a more scientific or mathematical brain, I might have been able to respond like so much better. Because basically I asked him, I'm like, you don't know how much force was exerted in the prior crash. And so you can't say if it was the same force as this crash. And he's like, well, both buses went on their side. So like it must have been the same force. And I'm like, oh my God, on what planet is that how scientific analysis works? had I had a brain that thought this way, I would have been like, sir, there's a scientific formula to calculate force, isn't there? And it's mass times acceleration. And you can't tell me the mass, and you can't tell me the acceleration. So you can't tell me the force then, and you can't tell me the force now. But instead we like bicker and split hairs over what force means for a little bit, I think. And we bicker over what a test is. He's like, well, I looked at the previous case, like that's a test. I'm like, oh my God, am I in crazy land? Oh, I was so mad. This is where things really went off the rails.
I know that the bus rolled over, and these are similar sized buses. So the force is going to be similar when a bus of that size.
That really, that didn't occur to me until you just said it.
Specific measurements from 19.
That really is a senseless answer.
So mad. I was like, this is just absurd.
1980, no, I do not.
Mr. Murray, I'm going to bring you back to my question. I'm going to ask you to answer. You do not know how much force was exerted on the windows in that other crash, do you?
I know it was similar to this crash.
Sir, you don't know how much force was exerted on the windows in this crash.
That's correct. I don't have a calculation.
You do not know how fast those vehicles were going in that crash back in 1980.
I do not know a specific speed.
You don't know how fast the vehicles were going in this case.
I don't think that is in the report. It's obviously fast enough to knock a bus over, but I do not know a specific speed.
Sir, you did not run any simulations or tests to see what would happen to glazed glass in the conditions of this accident.
Again, this accident is very similar to the accident previously, and in the industry, it's very common. What happens to glazed glass? It breaks but doesn't shatter.
Sir, I'm not asking about that previous accident. I'm asking about what
we
you
listen
did
to this,
to
my
prepare for
sir tick word is so fun. Love that. I thought that I had by this point eliminated all the filler words. If you start a question with and, or you start a question with whatever, but every question I'm saying sir, 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 and I hate that. I bet you the judges heard it.
It's an AMTA thing, I think.
Yeah, I think that I felt like it was me being a little condescending. It was kind of like, I'm putting you in your place, sir. And so I like that. And the more I listen to this too, I think if I could have changed something about this performance, as you mentioned before, witness control is something that's so important. And I had worked on it a lot to get to this point. And I was only using a lot of one technique, which is like, I'm not asking this, I'm asking this, I'm not asking this. And I think I needed to mix it up a little bit more. And honestly, when he gave the one answer that was like, well, I know the forces were similar, I truly, what I wanted to ask in the moment was, how do you know that without having run any mathematical calculations? Obviously, I exercised some degree of judgment and didn't ask that at the time. But all that to say, I definitely, watching this back, would have appreciated a little bit more variance in how I tried to control him. I don't know if it would have made a huge difference. Ultimately, me and him were getting into it at this point, but it would have been better, I think, overall.
This case,
Okay.
you did not run any tests or simulations to see what would happen to glazed glass in the conditions of this accident.
I consider a test simulation comparing it to similar accidents. If you consider it an actual mathematical calculation,
that is a wild answer.
Now, sir, you told us a minute ago.
A guy who's like theoretically a sort of scientific expert. So I read a story about another bus accident and thus test.
That's where my brain was at, which is validating to hear you say this, because I truly, again, it was one of those moments where I was like, am I in crazy town right now? Like, am I hearing the same words that he's saying? And I only could pray that the judges were similarly dumbfounded as I was, because I had done this cross, a good number of times leading up to the rounds, and I had gotten some pushback on a good number of questions, but nothing to this degree and nothing with this flavor of content. So it was a fun challenge. Fun is a loose term.
To go that it is, quote,
Yeah, you may have preferred to not have this witness in the national championship. Maybe like in a scrimmage.
I certainly preference.
cheap to glaze windows.
That is correct.
You mentioned that $87 cost, right?
That's right.
You know that that's an annualized number, don't you?
I believe it's a per production. So when you produce a bus, it's going to be $87 to do the windows.
Well, you know that the NHTSA, they're the ones who came to that number, right?
It is in that report. That's correct.
And they said that it was an average incremental material cost of $87.
Can you bring that up? I don't recall one way or the other.
Sure. I'm sharing my screen with the witness. It's showing a portion of Exhibit 23. Mr. Murray, can you see Exhibit 23 on your screen? It should be page 11.
That's right.
It says right here that it's an average incremental material cost of $87.
That's right, but it doesn't say annual. So I agree it's an average incremental cost of $87 and maybe 86 for one bus, 88 for another, but that's the average.
This is one of my
price per
great
bus.
regrets of my mock trial
Sir,
career.
you never ran any cost
So did you think it
analysis.
said annual?
No, it does say annual in the previous sentence. I highlighted the wrong sentence.
On your
Wow,
own.
let's go back.
So maybe 86 for
Yeah.
one bus, 88 for another.
An
but that-
annual incremental material cost, the very previous sentence.
That's the average price per bus.
Now, granted, to be clear,
Sir, you
I
never ran any.
most certainly did not understand the math of this. I don't think my team ever fully understood the math of this. I don't think we tried our best to, like, when we were on the plaintiff, use that number to our advantage, of course, just like this. And when we were on the defense, we would argue about what these terms really meant. To this day, I don't know what average annualized incremental cost means, but we just wanted to kind of throw enough haze over it that we could argue about it in closing. And so, yeah, I remember I finished up the cross finally and I sit down and I was like, oh, dude, I highlighted the wrong sentence. And it was just too late. It like came and went, and that was that. Ugh.
Cost analysis on your own, did you?
It's reasonable in my industry to rely on a government entity like that.
Sir, I'm not asking what you think is reasonable. I'm asking if you performed your own cost analysis, and you didn't, did you?
I relied on the one we just saw.
Sir, I'm going to ask you to answer my question. You did not run your own cost analysis.
I did not.
You did not look at any of Aero Coach's financials, did you?
I did not look at Aero Coach's financials.
Thank you, sir. I have no further questions, Your Honor.
Ian,
I mean, the impeachment by omission, obviously tough break. The annual versus incremental sort of $87 thing. You obviously could have been better, but everything else, amazing, I thought.
It's nice. We just got a little too in the weeds. That was one thing that, particularly with experts and particularly in TILA, I always kind of kicked myself a little bit, because if I had just kept it a little bit cleaner and a little bit more streamlined and kind of picked my battles a little bit better on some of that stuff, I feel like we could have just cruised right past it. And I ultimately, yeah, did I feel like I came out on top of the cross? Sure. But I feel like I could have, I lost my own, I shot my own self in the foot as I went, you know? And so there, you could always nitpick anything about your performance, but no, I mean, I was pleased with certain pockets and less pleased with others.
So this is obviously, again, the Thailand National Championship. It's this and AAJ are sort of the two big law school national championships. And you're one of, I think, competitors that I can count on one hand that have been in the college national championship and one of the law school national championships. Is that sort of occur to you? How does it make you feel?
At the time that we went to the final, I was very aware of it because, funny enough, so Miami won in 2018. The Yale Rhodes round went down in 2019, and so there was no champion that year. 2020 was COVID, so nationals was canceled. So when I sat for this final in 2021, all of my friends and I joked, like, we're still the reigning national champions from Miami. And so we all were like, oh my God, you could have two national championships at once, which what a jinx. And then we go lose the round. But it was very, I was very honored and excited, and it felt good. I mean, I was a captain at Miami. I was a captain on this wake team. And so my teammates were people, one of my teammates, Amanda, who was in this round, she had literally never done mock trial prior to our 2L year of law school. And so the fact that we made it all the way to the final, I mean, we joked all the time. We hit UCLA's other team of Stephen Douglas and Natalie Garcon in, I want to say, the quarters or the semis. We thought we were out that round. We thought we were out the next round. Like we felt good about our rounds. That's not to say we weren't talented, but we were just hitting these really crazy good teams too. And so, yeah, all that to say, I think that at the time I was very aware of it, which is probably why I choked a little under pressure. And now it's sort of something where I'm like, you know what? Even though anyone I meet on the street does not know this, it keeps me warm at night.
Yeah, it's something to be proud of. It's really hard to make the national championship for both events. I mean, you have several hundred teams, and to be in the final, I mean, most people don't even make Title Nationals and AMTA Nationals. I mean, there's very few people who've done both of those. Just being at those events, to be in the finals of both events. And my memory, and we'll cut this out if I'm wrong, you were best advocate of the prelims at Title Nationals that year, weren't you?
Yeah, they actually didn't do like prelim awards. They voted me like best of the final. So it was like, yes.
So you were the best advocate of the tournament then.
I mean, if you want to say it that way, that's what my resume says.
Perfect.
I did get a beautiful plaque that is up in my office. It's like there's like a man's name that the award is dedicated to, and it's a beautiful award. They like have a hand calligraphist who wrote my name and stuff like that. So it's quite nice.
Probably the name of the presiding judge who didn't know the Tyler rule about impeachment by omission.
If it was him, I would have asked for his John Hancock personally.
Well, a super big accomplishment and something to be really proud of, even with sort of the result going UCLA's way.
He deserved it. They were better.
They've had a really good stretch of years, and that was the first of their sort of run at Tyler, and AAJ and elsewhere. So a really good final. I think probably, I mean, the best, one of the better, I was going to say one of the best Tyler finals, but the last couple were UCLA too. So
we're good.
A string of really good Tyler finals. So how much money do you think we need to, or let me say it differently, how much do we need to be paid, you and I combined, to watch our performances from that nationals trial? Just sit through it.
How much money? I don't know. It's not a money level. It's sort of like if I can assure that no one will ever.
Well, that's part of it. We have to publish it and maybe even live stream it. So how much, like to a charity of your choice, how much money?
Ooh, you know what? If we can get the AMTA and law school trial communities to raise, we'll say $1,000, and you and I can agree on a charity.
Okay, fine.
I'll do it for the good of charity.
If someone pays us $1,000 and we will pay it to the charity of our choosing, we will sit through. And neither of us gave a speech in that round, so it's only two directs, two crosses. We will sit through them.
It looks like if that clip was of you objecting to my direct, it feels like this is going to be a lot more painful for me than it is for you. So can't wait.
I think I was ranked first on one of the ballots in that round. So
I know I wasn't, because my teammate won his All-American on that side. So I was certainly not giving him a run for his money.
I remember in that round, John made like some like painting analogy.
It was the Archer story.
Painting on a leaf or something.
It was the Archer story. They shoot they're like the best archer in the land. Everywhere you go, the arrow's right in the bullseye. And the king's like, how do you shoot so true? And he's like, well, follow me. And he pulls a quiver. I could do the whole thing. He pulls the quiver out. He launches the arrow into the woods, and he comes out and he pulls out a satchel of paint. And he draws the bullseye around the arrow, and he draws the rings. And he was like, and that's what the state did here. Or it was election fraud. So yeah, the state. Yeah. That's what the state did here. And I heard that story 1,000 times. And I ate it up every time, to be clear. It's a good story.
Yeah. And I remember in rebuttal, my teammate Andrew Donnelly got up and said, well, I'm not much of a painter, but I'm going to do my best to respond. Which I thought was
best response.
But kind of funny also.
Oh, that's perfect. That's all I think you can do with the other team. Classically Miami is being like so over the top. Like you just have to be like, well, I'm gonna do my best here.
Yeah, that was a fun one. And so we will, I think 1,000 might be too low.
Listen, like I said, it's gonna be more painful for me. So let's go 5.
Yeah, I think 1,000 would be pretty easy for people to raise. Let's go $10,000 to charity, not for us.
We'll spend time and find the appropriate organization.
Perfect. I love it. So are you doing anything mock related now?
That is such a great question, because I want to be so badly, not to throw shade to some of these Pittsburgh schools here, but I at least tried decently hard to get in with Duquesne last year. And by decently hard, I mean, I sent like a couple of emails and they kept kind of tabling me like, oh, we'll come back to you. And then I just never heard. And Pitt, I don't have any direct connections there. I'm truly at the point, maybe the person will see this. I am adding people on LinkedIn who I know coach the team, and I'm getting ready to like DM them because I want to be involved in coaching again. Like I said, I do have a slight preference for law school. And so if I can get into, coaching a TILA or AAJ team, that would be awesome. So I'm definitely trying to, but less involved than I would like to be.
What are you doing volunteering to coach teams in my region for?
Well, I'm in Pittsburgh. I'm just be in person with them.
You can coach Drexel via Zoom. There's AAJ's on Zoom this year.
Is it really?
It is.
Why?
I don't know.
No, that kind of sucks. No offense, but I mean, listen. You know what? If you want me to pop in, I'll certainly contribute.
There is a blank contract with your name on it to sign up to coach Drexel. You have an open invitation. We would love to have you in person or via Zoom if you want to commute to practices.
Really is about 6 hours for me, so Zoom might be a little better. But no, honestly, if you're being so serious, I have been dying to get more involved again. I'll like judge the occasional scrimmage for Miami or Wake via Zoom, and every time I'm like, oh man, I miss this so much.
We'd love to have you. Seriously.
All right. I'm emailing you right now.
There you go. What are you doing for work?
So I work for Jones Day in Pittsburgh. I'm in our battle group, which is business and tort litigation. Honestly, that kind of just makes me like a general litigator. I'm on an SEC litigation. I'm on some credit reporting litigation. I did like a standard breach of contract arbitration. The work I'm most proud of is my pro bono work. One of the benefits of being in big law, they've got a lot of money to kind of throw to some of these pro bono cases. So I've done a couple of prisoner rights mediation programs that we do through the Western District of Pennsylvania. And then far and away, my proudest representation is I represent a victim of child sexual abuse. We seek restitution for defendants who access those images on the internet. There's statutory requirements that they all owe restitution to my client because they've accessed those images. So it's not, overly legally complicated or factually complicated, but, I've met with this client and it is the most satisfying and really fulfilling work that I get to do. So very grateful.
Do you think that that's the kind of law you want to do long term, or do you think eventually you want to maybe do something that's more trial focused or at least trial-ish?
I definitely would like to be a little bit more involved in some trial work. I am very excited. One of my newer teams offers a lot of opportunities to junior associates. We had somebody who was 1 year ahead of me who did an entire bench trial on their own. So I'm definitely hoping to get some more of those opportunities with Jones Day. And if that continues to grow, I would definitely stay here for, an indefinite future. And if not, I think I'm kind of the view of you should never close yourself off to other options, but I'm very content where I'm at now.
Last question. I ask all of our guests this, and particularly those who are sort of have been in the mock trial sort of sphere for most of their lives, which as we have. Who is the greatest competitor of all time?
All time. Ooh, that's a great question.
Now, before you answer, let me just say this. You do get points deducted if you like equivocate or you say like 6 names. Like ideally here, you think about it for a second and then you say one name.
Okay, does it have to be somebody who I like competed with or against?
No, you can say any name you want.
And I can't do a cop out. And
it can't be me, obviously, because you didn't even remember that we competed against each other. So I'm out, obviously.
You were amazing. Okay, I think I would pick, and maybe this is just sticking in my head because I've watched that final enough time. I might even not have his name right. Jonathan Hartsfield.
Okay. Yeah, that's a good one.
Maybe back in, 2005 or something. He was the originator of I'm looking for a number, which as we saw in this cross, I wanted to use for every single question in 7 ways that didn't work. I think that for me, I wouldn't say that I saw a ton of his rounds. I've literally only ever seen that final. But to have originated a concept that is so widely used and so well known and like when I picture a round of mock trial, I can picture him saying that in the courtroom. I think that because that image is so planted in my brain, I would pick him. I was going to pick Neal, but that felt like a cop out because he was my coach. So I won't pick him. But honestly, he would probably be a pick too. And then you said don't pick more than one, so I'm stopping there. No more.
Perfect. Well, you've given your answer, so now you can say other names that I would have considered are, and I'll allow you to sort of give a few more.
Okay, so I definitely would have considered Nick Ramos. I mean, he absolutely dog walked me at trial by combat, so I'll have to give him his flowers. Steven Johnson, because he was at Cincinnati, we hit all the time or like scrimmaged all the time because we were just regionally so close. So he was fantastic and won trial by combat the following year. I would say Chris Grant from Northwood, who competed during my time. He had the art of trial down just so beautifully in a way that I was always so envious of. And the very last person I would say, she might have competed in undergrad, but I met her at Wake. Her name is Tracia Rice. She was a 3L when I was a 1L. They won their, I think it was actually a Wake versus Wake Tyla final, and Tracia won. She, again, is one of those people who I think of just like the art of mock trial. Oh my God, I could listen to her read a phone book and just be like, wow, this is the best thing I've ever heard in my life. So those would be my honorable mentions. Off the top of my head, I wish you had warned me about this question.
Sorry, you have to have, I mean, you told me you're a fan of the show, so you should know that I ask this question every time.
No, I haven't watched an episode in a while. Now I'm being called out again.
You're saying you don't make it to the end of the episode usually.
No, I've made it to the end of it.
You're usually so bored by whatever Benedemsky is saying at this point in the episode that you just turn it off. Well, Dani, thank you so much for coming on. I really value what I thought was the 9-year sort of friendship that we had, but in reality, I guess is only a 5-year friendship. I hope you'll come back on the show, given that we agree on some things, which makes me look good. And I am looking forward to coaching with you this semester.
Oh, that sounds lovely. Next time we can laugh at my horrific cross from my undergrad final. And so we can just really re-traumatize me over and over.
Perfect. You name the time and the place, and I'm happy to do that.
Thanks, Phil.